Welcome back to Canadian Justice, where we're discussing a legal challenge to air passenger protection regulations that has been brought by the airline industry. Now, John, this is a challenge that was just heard at the Supreme Court. The airline industry is looking to have these protections for international flights struck down, arguing that they're outside the scope of the agency's authority to enact and that they violate the Montreal Convention. So my question is kind of about if these protections are upheld, if the Supreme Court says, no, these are the rules, you have to pay compensation, do you think it's going to change anything? Do you think that it's going to make flight delays better? Do you think it's going to make the compensation regime better? Do you think it's going to help passengers if this is upheld?
I don't think so. I think that if the Supreme Court appeal, does a rejects the IATA motion, and it has appeals the APPRs. I think the airlines know that their choices for appeal are few and far between. There's nothing left for them to do. So I think they'll just keep dragging their feet, make life more difficult, and it'll be up to the Canadian government and the CTA to now put out some more significant things like administrative monetary penalties that Gabor talked about earlier at 25,000 or to $250,000 limit. That is now going to be the tool that will, in fact, be used to get the airlines to pay attention to their violation of not paying compensation.
Gabor, what do you think? If these protections are upheld, if the Supreme Court says, no, these regulations are within the authority of the agency to create, that they're no violation of the Montreal Convention, these regulations apply, do you think it's going to make things better for passengers? Or do you agree with John? Are you pessimist?
Certainly, if the regulations were struck down, it would be worse for passengers because you cannot reverse things to the state they were before the regulations. So many provisions that have previously been now have been replaced by the APPR obligations, and it would be a problem practically. And what I've been arguing actually before the High Court is that if they were to strike it down, at least a 12-month period should be left for Parliament to step in. Because what Canada could do is that Canada could say, well, notwithstanding the Montreal Convention, Parliament still wants the APPR. That option is open to Parliament because Parliament is sovereign, and the Montreal Convention cannot tie the hands of Parliament. Certainly, it would make things slower. It would result in people not getting compensation they thought they would be receiving. So the appeal being granted would cause a lot of harm. The appeal being dismissed based on the reasons would either be neutral or possibly could narrow down the Montreal Convention in a dangerous way, which I hope the High Court will avoid. But ultimately, I agree with John's assessment that what is needed here is a genuine commitment to enforcement, which has been sorely lacking by the Canadian Transportation Agency. The fines that have been issued so far are just laughable, both in amounts and a few cases that actually they have been issued. There should be a zero tolerance policy on violations of the law, because after all, this is about the rule of law. The law should apply the same way to the average passenger, the average taxpayer, and large corporations. And if we are cutting a slack, it should be to the average citizen, not to large corporations who have the resources to know the law, who have lawyers who can tell them what the law says.
Yeah, John, anything you want to add there? I'm particularly interested in if the airlines win, if these regulations are struck down, how big of an impact is that going to have on passengers? And do you think the government would react immediately to bring some change in by way of legislation?
All depends on the strength of the lobby that the Canadian airlines are having with the Canadian government. This will strike down the international component of regulations. The Canadian regulations for domestic services will still be in place. I don't think we can live with a dichotomy between Canada and international air travel. We've done in the past, but I think this is much too important of an issue. We need to have a common application of regulations across all services. So if the airlines win the international one, there'll be a lot of pressure being put on the government, either through discussions, dialogue, lobby, or eventually maybe back to court to talk about getting rid of the Canadian portion of those regulations. So those regulations would have what I would call a very short shelf life if the appeal is won by the airlines.
Right. We've got to go to commercial break now, but when we come back, I want to talk to you, Gabor, about what your experience was like arguing yourself as an intervener at the Supreme Court. We'll be right back.